Have you ever felt like you were treated unfairly at work? Not because of your performance, but because of who you are. Maybe you were passed over for promotion, harassed, or even fired. That brings us to a crucial question. What exactly counts as workplace discrimination under U.S. law? Here's the truth. Not every unfair decision is illegal. Under American law, workplace discrimination happens when an employer treats you differently based on a protected characteristic like race, gender, age, religion, disability, or other categories defined by federal or state law. In this video, I'll explain what workplace discrimination really means, the laws that protect you, the types of conduct that are illegal, and what you can do if you think you're a victim. Understanding this isn't just about knowing your rights. It's about protecting yourself and helping build fair workplaces. Part 1. The legal definition of workplace discrimination. At its core, workplace discrimination means being treated differently or unfairly because of a protected characteristic. U.S. law doesn't cover every kind of unfair treatment, only those tied to categories specifically protected by federal or state statutes. The main federal law is Title VII of the Civil Rights Act of 1964. Title VII makes it illegal for employers with 15 or more employees to discriminate based on race, color, religion, sex, or national origin. Over the years, courts and the Equal Employment Opportunity Commission, EEOC, have clarified that sex also includes pregnancy, sexual orientation, and gender identity. Other federal laws expand protections. The Age Discrimination in Employment Act, ADEA, protects workers who are 40 and older from age-based discrimination. The Americans with Disabilities Act, ADEA, prohibits discrimination against qualified individuals with physical or mental disabilities and requires employers to provide reasonable accommodations. The Equal Pay Act of 1963 requires men and women to be paid equally for substantially equal work in the same workplace. The Genetic Information Non-Discrimination Act, GINA, bans discrimination based on genetic information. Discrimination can happen in many aspects of employment, not just hiring and firing. It also includes promotions, pay, job assignments, training opportunities, layoffs, benefits, and any other term or condition of employment. Importantly, discrimination doesn't have to be blatant. Sometimes it's obvious, like a supervisor saying, "We don't hire women for this role," but it can also be subtle, like consistently giving less desirable shifts to older workers or overlooking qualified employees with disabilities for promotions. To qualify as illegal discrimination, the conduct must be tied to one of these protected categories. If your boss plays favorites because they just personally like one worker more than another, that may be unfair, but it's not discrimination under federal law. If the favoritism is tied to race, gender, or another protected trait, that's when it crosses into illegality. So under U.S. law, workplace discrimination isn't about whether a decision feels unfair. It's about whether it was made because of a legally protected characteristic. Part 2. Common forms of workplace discrimination. Now that we've defined what discrimination means under U.S. law, let's look at the most common ways it actually shows up in the workplace. Discrimination isn't limited to hiring and firing. It can touch almost every aspect of a job. Hiring discrimination is one of the most visible forms. This happens when an employer refuses to hire someone because of race, gender, age, disability, or another protected characteristic. Imagine applying for a job and being told, "We don't hire older workers," or noticing that equally qualified women are consistently passed over in favor of men. That's illegal. Even job ads can cross the line. For example, postings that say "young and energetic" may discourage older applicants and raise legal issues under the Age Discrimination in Employment Act, ADEA. Firing discrimination occurs when an employee is terminated for a protected reason. For example, firing a woman after she tells her boss she's pregnant, or dismissing an employee because they requested a religious accommodation. Under Title VII and the ADA, those terminations are unlawful. Pay discrimination is another major issue. The Equal Pay Act requires men and women to be paid equally for substantially equal work in the same workplace. Yet many workers still discover that coworkers of the opposite sex earn more for doing the same job. Unequal pay based on gender or on race, disability, or age can be challenged under federal law. Promotion and advancement discrimination happens when protected traits are used as a barrier to career growth. An older worker may be passed over for promotions in favor of younger colleagues, even when experience and performance suggest otherwise, or employees with disabilities may be excluded from leadership tracks under the false assumption they can't handle it. Finally, harassment is considered a form of workplace discrimination when it's tied to a protected characteristic. This includes sexual harassment, racial slurs, offensive jokes about religion, or hostile treatment because of disability. Under Title VII and the ADEA, harassment that creates a hostile work environment or results in a tangible job action, like demotion or firing, is illegal. The important thing to remember is this: discrimination doesn't have to be a single dramatic event. It can be patterns, lower pay, fewer opportunities, or constant harassment that add up over time. If those actions are linked to a protected trait, they're not just unfair, they're unlawful under U.S. law. Part 3. How workplace discrimination is proven. Knowing that discrimination is illegal is one thing, but proving it is another challenge. Employers rarely admit, "I fired you because of your age," or "we don't promote women." Instead, workers must rely on evidence to show that a decision was motivated, at least in part, by a protected characteristic. One type of proof is direct evidence. This is rare, but powerful. Direct evidence might be an email from a manager saying, "We don't want to hire anyone over 50, or a supervisor openly telling a pregnant employee, "We need someone who won't go on leave soon." When direct evidence exists, discrimination cases are much easier to prove. More often, employees rely on circumstantial evidence and patterns. For example, if women in a company are consistently paid less than men in the same role, or if only younger workers are promoted despite similar qualifications, those patterns may point to discrimination. Courts and the Equal Employment Opportunity Commission, EEOC, look closely at these trends. Lawyers often frame cases using two concepts: disparate treatment and disparate impact. Disparate treatment means intentional discrimination. An employee is treated worse, specifically because of their race, gender, religion, or other protected category. Example: refusing to promote a worker because of her age. Disparate impact doesn't require intent. It happens when a company policy looks neutral on its face, but disproportionately harms a protected group. For instance, if a company requires all employees to pass a physical strength test that isn't actually necessary for the job, and that test screens out women or older workers at higher rates, that policy may be illegal, unless the employer proves it's job-related and necessary. Another important factor is timing. If a worker is fired soon after requesting medical leave, filing a discrimination complaint, or asking for religious accommodation, the close timing can suggest retaliation or discriminatory motive. Employees can also use comparisons to prove discrimination. If a worker is disciplined harshly for a mistake, but others outside the protected group make the same mistake without consequence, that double standard can support a claim. Finally, the law requires an employee to show they were qualified for the job and suffered an adverse action like firing, demotion, or lost pay, while someone outside their protected group was treated more favorably. This legal framework, known as the McDonnell-Douglas burden shifting test, is often used in court. So while discrimination isn't always obvious, the law recognizes both direct bias and hidden practices that harm protected groups. With the right evidence, Employees can prove their case, even when employers deny wrongdoing. Part 4. The role of the EECC and how complaints are handled. When you believe you've been discriminated against at work, one of the first places to turn is the Equal Employment Opportunity Commission, EEOC. This federal agency enforces many of the key workplace discrimination laws, including Title VII, the ADA, the ADEA, and the Equal Pay Act. Here's how the process usually works. If you think you've been a victim of discrimination, you must file a charge of discrimination with the EECC before you can bring a lawsuit in federal court. This charge is a formal statement explaining what happened when and why you believe it was illegal. In most cases, the deadline is 180 days from the Discriminatory Act, though in some states with their own human rights agencies, the deadline extends to 300 days. Once the charge is filed, the EECC notifies your employer and begins its investigation. This may involve reviewing documents, interviewing witnesses, and asking the employer for a written response. Sometimes the EECC will suggest mediation, where both sides meet with a neutral third party to try to resolve the issue without a lengthy investigation or lawsuit. If the EECC finds evidence of discrimination, it can try to settle the case with the employer. If settlement isn't possible, the EECC may choose to file a lawsuit on behalf of the employee. However, because the EECC has limited resources, in most cases they issue a right to sue letter, which gives the employee permission to take the case to court on their own with a private attorney. The EECC also plays a big role in preventing discrimination. It issues guidance to employers, educates workers about their rights, and collects data on employment trends. For example, it tracks charges filed by type, such as race, sex, age, or retaliation, which helps reveal nationwide patterns. It's important to note that the EECC process is confidential, and employers are prohibited from retaliating against employees for filing charges. Retaliation itself is the most common type of charge the EEOC receives, which shows how often workers face backlash for speaking up. In addition to the EECC, many states have their own human rights or fair employment agencies, sometimes called FEPA agencies. These often work together with the EECC, meaning when you file a complaint, it may be dual filed at both state and federal levels. So, the EECC isn't just a bureaucratic stop, it's the gateway to enforcing workplace discrimination laws. Filing a charge is often the first formal step in holding employers accountable when they cross the line. Part 5. What workers can do to protect themselves in real life. Examples. Understanding the law is one thing, but what can you actually do if you believe you're facing workplace discrimination? The answer starts with protecting yourself through documentation and knowing where to turn. First, keep records, save emails, text messages, performance reviews, and any written communication that shows patterns of unfair treatment. Write down dates, times, and details of incidents, especially if you hear biased comments or notice inconsistent discipline. Witnesses can also help. If coworkers observed discrimination or harassment, their statements can support your claim. Second, know your rights internally. Many companies have HR departments or complaint procedures. Reporting discrimination internally creates a record and sometimes leads to resolution without outside action. But remember, retaliation for filing an internal complaint is illegal too. Third, if the problem continues, file externally. As we discussed, the EEC and state agencies handle discrimination complaints. Acting quickly is critical because deadlines are short, often just a few months after the Discriminatory Act. Fourth, consider consulting an employment lawyer. Attorneys can help evaluate your case, guide you through the EEC process, and, if necessary, file a lawsuit. Many work on a contingency basis, meaning they only get paid if you win. It's also useful to learn from real cases. For example, a pregnant worker was fired after requesting light duty. The EOC sued under Title VII's Pregnancy Discrimination Act, and the employer paid damages and changed its policies. A group of older sales representatives in a tech company were consistently denied promotions in favor of much younger staff. After filing an ADEA claim, they secured a large settlement and new training policies. A cashier with a disability was denied a modified schedule, then fired for missing work. Under the ADEA, the court found the employer failed to provide reasonable accommodation, and the worker received back pay. These cases prove a point. Discrimination is often hidden behind vague excuses like not a good fit or performance issues. But when workers document what happened and use the law, they can win meaningful remedies: back pay, reinstatement, policy changes, and even damages for emotional distress. The bottom line: if you suspect discrimination, don't stay silent. Keep records, file complaints, and remember, you're not just standing up for yourself, but also helping protect others in the workplace. So, what is workplace discrimination under U.S. law? It's not just about feeling treated unfairly. It's about being treated differently because of a protected characteristic, like race, gender, age, disability, religion, or other categories covered by federal and state laws. Title VII, the ADA, the ADEA, and the Equal Pay Act form the backbone of these protections, with the EEOC and state agencies enforcing the rules. Discrimination can appear in many ways: hiring, firing, pay, promotions, or harassment. Sometimes it's blatant, but often it's subtle patterns that only become clear over time. That's why documenting your experiences and acting quickly is so important. If you believe you've been targeted, remember, you're not powerless. File complaints, seek legal advice, and use the protections available. By standing up, you not only defend yourself, you also help create fairer workplaces for everyone. If this video helped, hit like, share it with someone who might need it, and subscribe for more plain English guides to workplace law.